Hi, my name is Sheila. Welcome to the video. We are going to be talking about this whole Mariah Carey All I Want for Christmas lawsuit. This lawsuit comes to us from Louisiana, Eastern District, and it is Andy Stone, and I think the other name he goes by is Vince Vance. All right, let me pull this up so we can take a look at it to see exactly what he was suing her for, because now apparently he's not going to be suing her anymore. Plaintiff Andy Stone, aka Vince Vance, through his undersigned attorneys, allege against defendants as follows. Let's jump down to the facts and allegations on this. It says, Plaintiff Vance is a self-employed artist in the business of performing, selling, and licensing his copyrighted music and earns his livelihood from fees received from these activities. Okay, heard of that before, all good. In 1989, plaintiff co-wrote All I Want for Christmas Is You and recorded it at the Masterphonics Studio 6 in Nashville, Tennessee. It was subsequently released on the record label Valiant 92689 with an accompanying music video. Okay, didn't realize there was a video with it, but hey, you learn something new every day. After receiving extensive airplay during the 1993 Christmas season, plaintiff's All I Want for Christmas Is You began making appearances on the Billboard music charts. All I Want for Christmas Is You is copyrightable subject matter under the laws of the United States. And of course, then he goes through here, he shows his registration. Then he starts talking about Mariah Carey's song. It says it was released by Columbia Records, owned by defendant Sony, on or about October 28, 1994. Made a part of the Merry Christmas album. That's where the version was released, along with accompanying music videos. So of course, I think everybody's seen her videos. Okay, so here's where he starts to make the statements. It says, defendants never sought or obtained permission from plaintiff to use All I Want for Christmas Is You in creating, reproducing, recording, distributing, selling, or publicly performing said song. It says plaintiff never gave defendants permission, consent, or a license to use All I Want for Christmas Is You for any purpose, including the creation of a derivative work based on All I Want for Christmas Is You. On information and belief, defendants have in the past and or presently continuing to reproduce and distribute to the general public worldwide, oh yeah, it's out there, via the internet and interstate commerce, copies of plaintiff's work, All I Want for Christmas Is You. So yes, last piece says defendants have knowingly, willfully, and intentionally engaged in a campaign to infringe plaintiff's copyright in the work All I Want for Christmas Is You and to commit acts of unjust enrichment by the unauthorized appropriation of plaintiff's work and the goodwill associated therewith, all of which are proprietary to plaintiff as set forth herein, to the commercial gain, personal profit, and unjust enrichment of defendants, and the irreparable injury and financial loss of plaintiffs. So he's basically saying they got some money, they received money as a result of infringing on my song over here. But here's the thing. The title of a song, the title of a book, the title of a movie in and of itself, just that is not copyrightable, okay? It has to be something in a tangible medium. And this just sort of label for something is not quite enough, okay? So for instance, if it was a title of a book, it would be the book that would be copyrightable. That would be what you would be registering. The words inside. We've got a whole idea that's been put into a tangible form. A title, not so much. He goes on to say at all relevant times he was and continued to be the owner and have the copyright in the work All I Want for Christmas Is You. And then it says defendants, meaning Ms. Carey and Sony and others. Defendants should have known of plaintiff's copyright in the work All I Want for Christmas Is You. Okay, so I'm going to stop right there for a second because I did do a little bit of research this time. I don't always research these before I start reading them. And apparently, I think Deadline and Rolling Stone sort of talked about this. There are at least 170 plus titles out there of those same words that say, All I Want for Christmas Is You. So in what world are you necessarily responsible to look at titles when titles are not something that are things that you would register a copyright on? Okay, we will come back to that. So he says, upon information, believe defendants knew or should have known that he had this copyright in his work. Here's the one that really gets me here. Plaintiff became aware of defendant's use of his work, All I Want for Christmas Is You, without license, right, or authority, and by producing and distributing to the worldwide general public via the internet and interstate commerce. Plaintiff's counsel initially made contact with defendants in April of 2021. Okay, so they actually made the song back in 1994, let me scroll back, 94. He made his in 1989. Yes, released by Columbia in 1994. So where has this guy been all this time? Because I remember when All I Want for Christmas came out, and it was a really big deal, and then it sort of dropped off, like everything does. And in recent years, it sort of picked back up. Now it's like every year when Christmas comes around, like that's number one every single time. People are just, interested in Mariah Carey's song, and it's playing, and, it has that very pop feel. It has a good feeling to it. So I don't know where he was all of these other years. And it says in 2021 is when he all of a sudden decides that, you know what, I'm going to have an attorney. Because this is what it says. Plaintiff's counsel initially made contact. Not this was the third time or fourth time in 2021. This was the first time we decided to send something to them to let them know. I don't know, maybe it was really big that year and that was the year he heard it. I have no idea. But that is the weirdest thing. I don't know. Especially, it'd be different if he were not in the music industry. So they're in the same industry. Now, granted, the song, if you listen to it, the version that I listened to had a very country blues feel to it. Like it was a really good song. I actually liked it. It was a good song. Just not the same song. You've got something pop that sounds very different over here, something country with a bluesy kind of background and feel to it. Not the same song, but you're in the same industry. It's like not knowing who your competitors are. Who do you think was playing and showing up at, for some of these awards? She was there. I don't get it. So it says plaintiff's counsel, he had his attorney send a letter via certified mail on or about December 20th, 2021. Oh, so let me get this straight. Not only did you wait like 20 something years, like 25 years to contact them about it, you then waited until it was Christmas time. So it's December 20th before when you decide to send it. Maybe he heard it on the radio and thought, now is the time because that sounds like my song. Yeah. It says, thereby putting them on notice that the creation, a derivative work without authorization and payment to plaintiff represents a violation of plaintiff's rights. Defendant's actions. Okay, Ms. Carey, you have deprived me of just compensation in association with the use of All I Want for Christmas Is You, thereby causing me financial and professional damage, and if allowed to continue, will cause further injury to plaintiff. I'm sorry, but I've never heard of him. I did not know that there was this. I'm sure there are plenty of versions out there. First of all, we know that there are tons of remakes of what she has made. She has even done some duets with other people. So there are other people who have taken her version and have done their own version of it. So the fact that, he's saying, there's some just compensation I'm missing because you did something, a song with the same title, but it doesn't sound like the same thing, doesn't have the same harmony or anything like that. The genre is different, and the words, the lyrics, you guys look up the lyrics. He then goes on to say, even after communicating the concerns with defendants, plaintiff was unable to come to any agreement over usage of All I Want for Christmas Is You. Subsequently, plaintiff personally requested that defendants cease and desist from further distribution. Now, can you imagine being Sony and getting this letter and then being told, oh no, you need to stop? And they have had this out since 1994. Can you imagine? They're like, dude, no. That's an easy one for them. Thereafter, on April 5th, 2022, plaintiff purchased the Merry Christmas album incorporating the song All I Want for Christmas Is You from Louisiana Music Factory, located at wherever in Louisiana. In fact, defendant's Merry Christmas album incorporating the song remains available for purchase at retail outlets throughout Louisiana. Yeah, that thing's available everywhere. It's on iTunes because I went to listen to it for this. Even though I already know the song, I just wanted to hear it and then look at his lyrics to see if there was something I was missing. I wasn't missing a thing. Next up, unjust enrichment and appropriation and misappropriation. The false representation of professional collaboration and association, the failure to give notice to the public that plaintiff is the owner of the work, you got to be kidding me, and that plaintiff does not endorse the defendant's endeavors and other acts more fully described above. Plaintiff is the owner of the work. That, that one is interesting because then at that point, you aren't just talking about your work that you created. What are you talking? Are you talking about their work? Because it's not even really clear here what you're talking about. I'm reading this and I'm not entirely sure what it is you're trying to really say here. You're entitled to your work. You're the owner of your work. That's obvious. That's clear. There's no question about that. But to now sort of say that you failed to give notice to the public that plaintiff is the owner of the work, I know you're not talking about Mariah's work because you didn't write any of that. You didn't contribute to that. There's a title that's the same. And maybe I'm missing something, but I looked at the lyrics and I listened to the versions. I just don't think I'm missing a whole lot. Listen to it. People, listen to it. Let me know if there is something that I missed. I just don't think so. Defendants have in the past and continue to use in connection with their commercial services and merchantable goods, plaintiffs' work in interstate commerce, contributing to the false and misleading representation of that has resulted in financial loss to plaintiff. So now they're alleging that because of this song that's out here, they've lost money. Upon information and belief, defendants' acts were designed to exploit the popularity and unique style of plaintiff, causing confusion as to the association of defendants and plaintiffs' endorsement, sponsorship, and approval of plaintiff's work. No. Okay, I already said this. I said this up front. When you start talking about goods and services in the marketplace and whether or not there is confusion, you take into account all of the circumstances related to that. What did I say up front? Her song is very pop. It has a very pop sound to it. The song that I listened to did not. It had a very country vibe to it with some blues. That was one of the things that surprised me because I thought it was going to be totally sort of country sounding, but it wasn't. I listened to it and I was like, oh, there's some blues in there, but there's no pop in there. I didn't feel like it was a pop song. It just didn't hit me that way. That was not the vibe that I walked away from. If people listen to those two songs, I don't think that there's going to be any confusion that was his song. That's his song, because I remember what I was saying before I got cut off there is they're just very different. I just don't see this causing confusion here. I just don't see it. At the end, they get to the ask. The ask is, as a result of the willful copyright infringement, they're asking for punitive damages and compensation for the damages sustained in an amount not less than $20 million. And I'm just going to stop there. This lawsuit, thank goodness, is gone. It's gone, it's gone. For just a few last thoughts. So this has been dropped, and I'm pulling up just a couple of news articles because this really just came out just earlier today. He has dismissed the lawsuit. However, it was without prejudice, so he can bring this lawsuit back. One of the things I think they said in the People article that I'm taking a look at, because like I said, I had never heard his song before. It said it had actually reached, this is propelling the country ballad to number 55 on Billboard's Hot Country Singles and Tracks chart. Yeah, so I mean, it did reasonably well, and I can understand that because I listened to the song. Like I said, it was a good song. It just wasn't substantially similar to hers. That's it. Don't forget to like the video, subscribe to the channel, and peace.